thank you everybody for coming to the second in our accommodation series. We will try to address questions throughout. Both Barbara and I will try to keep an eye on the chat panel for questions and answers and get to those as we go, but we'll also save some time at the end to the extent that we can to address questions. So please feel free to use that throughout, and we'll keep an eye on it. We'll try to get to them. Can't promise we'll get to them all. Hopefully there'll be a lot, but I'm sure we'll both be available, can make ourselves available afterwards for any kind of discussion of particular points of interest for anyone out there. So with that, I'll hand it over to Barbara. Thank you.
Okay, thank you, Seth. Can you pull up the first slide, please? Great. So I don't think I need to tell you this, but just wanted to remind all of us that enrollments in programs with clinical components are increasing very quickly, perhaps as a result of the pandemic or for other reasons. Healthcare enrollments are really booming. And as I'm sure you know, many of these programs do require a clinical component so that the students can practice what they've learned in the classroom. You may also have seen in the press that there's a exodus of K-12 teachers, unfortunately. So there's a very strong market for new teachers. And for those of you who have a background in education, you'll know that student teaching is an important part of that. These difficulty in finding and retaining K-12 teachers is so difficult that it's even become the subject of a cartoon. And earlier this week in the Washington Post, there was a cartoon of a school bus full of children. They looked as if they were maybe in third grade. And the school bus driver was saying, okay, children, now open your books to chapter 4, and we will discuss the content of the chapter, suggesting that school bus drivers are doubling as teachers. That's really not very funny, but I'm afraid it's a reality that I suspect those of you who have K-12 education programs are dealing with right now. Social work enrollments have also increased, and social work degrees often require a clinical component. And then career-oriented programs just in general are becoming more popular as students, and particularly their parents, are concerned about post-college employment opportunities. Next slide, please.
Thanks, Barbara. Can I just note here too that there is an increasing focus on applied learning as an aspect of other types of programs, particularly in business, media, entertainment, areas like that. So many have always had internships have been a strong part of the educational experience, but not necessarily an integrated part of the academic program. And I think that's changing a little bit, becoming more integrated, and colleges and universities are getting more deeply involved in sending students for applied learning and experiential education programs as part of those programs. And with that, I'll just note as well, we tend to focus on clinical education and K through 12 teacher education, things like that, because they are such a big part of the applied learning landscape. But the terminology I think that we use and the laws that apply, most importantly, that we talk about, apply pretty broadly and very similarly, regardless of whether you're talking about an internship on Wall Street or a clinical rotation as part of a medical science program.
Absolutely, Seth. I couldn't agree more. And frankly, the more clinical experience a student has, the more attractive they are to a prospective employer. So students are looking for these clinical opportunities when they decide which college or university to apply to. So the next slide talks about the legal background, which I suspect all of you are familiar with. I just, again, want to remind us all that there are both federal laws, the ADA and Section 504, that deal with the requirement to reasonably accommodate students with disabilities who are qualified and can meet the standards. And we'll talk about the standards in a few minutes. There's a New York Executive Law 296.-C that requires even unpaid internships to have accommodations, reasonable accommodations for students, and also accommodations for pregnancy. And then, of course, you have your own institutional policies with respect to non-discrimination, which could raise breach of contract claims if the students feel that those have not been followed. Next slide, please.
Thanks, Barbara. I'm glad you brought up pregnancy as part of the human rights law, New York Executive Law. And I will just note there, and we may mention it again later, but the new Title IX regulations that I should say proposed Title IX regulations really place a greater emphasis on pregnancy and pregnancy-related condition accommodations, which for most part are to be treated very similarly to disability-related accommodations. So that's an area where we'll be watching closely. And probably another law we could add here is Title IX, even though it doesn't specifically address disability.
Okay, so looking at this issue from the perspective of the clinical setting, many of these, in fact, probably most of these clinical settings are not part of the institution, the college or university. So the college or university in some ways is, I'm not sure I should use the word at the mercy, but certainly is dependent on the willingness of the clinical partner to accept its students and to give them the kind of clinical experience that they need in order to fulfill both their academic requirements and possibly for licensure. For example, medical students, other sorts of medical related careers require licensing, pharmacy, for example. So here's some typical accommodations that students have requested for the classroom part of their experience: extra time or assistance with reading. Well, if you're in a busy emergency room or a hospital, you may not have the opportunity to spend extra time reading a prescription or the written orders of a doctor or something similar to that. Communication requirements. Communication is incredibly important when a professional is dealing with clients, but sometimes how something is said is just as important as what is said. And if the student has issues with communication or has difficulty communicating clearly, that could be a real problem and probably difficult to accommodate. The litigation that I've reviewed, and believe me, there's a lot of it, focuses quite a bit on behavioral requirements for students in these clinical settings with respect to how they deal with their supervisors, all right? How gracefully they accept criticism or suggestions, and it's students sometimes have difficulty dealing with that kind of requirement, but as a professional, we all need to deal with those requirements, of course. And then physical requirements may in fact make it difficult for a particular student to fulfill the requirements of the clinical assignment. So again, from the perspective of the clinical setting, they have financial and personnel constraints as well as colleges and universities do. They have to follow government regulations clearly. They certainly have to follow accreditation requirements, particularly in healthcare, but in some of the other industries that we've talked about. And then we both Seth and I will be talking quite a bit about the academic and technical standards, which have to be linked to the position of the student. What's the job that the student is focused on, and what are the academic and technical standards that have to be followed? Did you want to comment on that, Seth, or should we move on?
We'll talk about academic and technical standards, I think, a bit later. I will just note, I guess, at this point that every one of the points that you emphasize with regard to clinical settings would apply in many other settings, especially, I would say, teacher education, behavioral. There's a huge behavioral component. Acting appropriately in front of a classroom is a huge part of that, and something that you always want to keep an eye on. You mentioned social work earlier. That's another one in the healthcare field, but being able to interact appropriately and in a therapeutic way with clientele is hugely important in those areas. I'll talk about it again later, but where we really need to be watching early on through the educational process to be able to identify potential issues.
Okay, next slide, please. Seth, could you put up the next slide, please? So just again, a reminder, don't need to spend a lot of time on this, of what students have to do in order to be possibly entitled to reasonable accommodations. They have to provide written documentation of their disability. They have to request accommodations from either the college or university or the clinical site. They have to be able to meet the academic and technical standards that we just spoke about briefly a minute ago, and we'll spend a lot more time talking about that, including professional conduct, as Seth suggested. I can't think of a profession that doesn't require professional conduct, frankly, maybe theater, I don't know. But other than that, we have to be able to interact appropriately with clients or customers or patients. And then the students must show that they are, quote, qualified. Again, that's what the law says, in that they can meet these standards. Okay, next slide, please. And then I just wanted to mention our good friend, the Office for Civil Rights, because many of the complaints brought by students do go to OCR. Some of them go to court, but many of them go to OCR. And I was quoting a letter from OCR here to a college a few years ago, and talking about how it decides whether or not the academic and technical standards are appropriate, and whether the institution has basically defended its creation of these academic or technical standards. They have to show that they've gone through a reasoned and informed process. And if they can show that and show that it's an academic, it's connected to the academic part of the program, then typically OCR will defer. And the best way, and what I've seen in both OCR letters and also court opinions, is that a group of experts in whatever the profession or field is got together and went through word by word, really, the academic and technical standards that they are creating. You can't just say, well, the dean will decide based on whatever the dean thinks is appropriate. They need to be in writing, and they need to have been created by, I would strongly recommend, more than one expert to at least to demonstrate that there was a very thorough and thoughtful process that was gone through. Next slide, please. Okay, and then what does the clinical setting have to show? That the accommodation, if the clinical setting believes that the accommodation that's requested is not reasonable, they would have to show that it requires what the regulations call fundamental alterations in training that they're providing or in the curriculum, in that what the student is asking for is to avoid a particular requirement. That's the typical approach, that the student doesn't want to have to be able to take a blood pressure, or the student doesn't want to have to be able to follow the rules with regard to the way students are treated. And the clinical setting, if there's a challenge by the student that they cannot do that, they cannot meet that standard because of their disability, the clinical setting or the college or university, depending on the situation, would need to demonstrate that that accommodation just is not reasonable because it has removed a very important chunk of the requirements. And also, particularly in the kind of programs we're talking about today, that removing this requirement exposes students and or clients and or patients to direct threats to their safety. If a student can't get along with a supervising physician and argues with a physician about the treatment, for example, of a patient, that could be a direct threat to the patient's safety. Next slide, please. So here are some suggested or experience, I guess I could say, challenges that institutions have faced in litigation. Learning disorders, I know you're very familiar with these, and colleges and universities, I think, have been fairly successful in accommodating students with learning disorders in the classroom part of their programs. But what if there's a requirement, for example, of reading comprehension or reading speed in a clinical setting, and the student, I've seen some cases where the student says, well, you're going to have to write out your instructions because I can't process through my ears instructions. And the supervisor says, I don't have time to write it down. I need to be able to explain it to you, and you need to do it. And time is wasting, and the patient or the client is at risk. So that's an example, for example, of problems with accommodating learning disorders, and certainly not all learning disorders. It's just marrying the limitation of the student with the requirements of the clinical of responsibility. Mental health issues tend to be challenged. Many of the academic dismissals from the clinical site have involved unprofessional interactions with clients or patients, or difficulty conforming to a supervisor, requirements. Sometimes students, for very understandable reasons, need a flexible schedule. Students with Crohn's disease, for example, may need a flexible schedule because their difficulties come in an unexpected way and unpredictable way. But the site is counting on these people. You can't have a student teacher call up and say, I can't come in today, or I can't be there till noon, when there's no coverage for the class. So physical limitations, eyesight, I'll be talking about a couple of cases in a moment. Mobility limitations may be a problem for certain kinds of clinical settings, or the inability to interface with the technology that is necessary to perform the job. And then, of course, service animals. Are service animals even going to be permitted, for example, in a healthcare setting? So there's a lot to think about when you are matching up students' needed accommodations, legitimate accommodations, with the needs of the clinical setting. Next slide, please. Okay, and then this is just some examples of student legal challenges. And these are cases that have been decided by the courts, usually federal courts. A student, for some reason, who had visual impairments, asked that he not be required to use optometry instruments in an optometry program, and the court made pretty short work of that one. A visually impaired student was not admitted at all to medical school because she couldn't perform routine medical actions like inserting an IV line, or checking blood pressure, or reading x-rays. Some accommodations threaten patient safety. I gave you a couple of examples of that a couple of minutes ago. In the situation with student teaching, sometimes students' disabilities may interfere with their ability to carry on in a professional, thoughtful, appropriate way with students, and even sometimes follow the state education requirements for licensure. I won't go into details about that, but some students have unusual beliefs about dealing with young children and their sexuality, and that typically does not meet the state licensing requirements for a teacher. And then the student just couldn't physically perform the essential functions required for licensure, and this particularly in healthcare settings, but in others as well. Okay, next slide, please. I think it's over to you, Seth.
Yeah, thank you. Thank you very much, Barbara. I'm gonna, a couple of issues came up, or a couple of questions came in related to what you were speaking about, and I figured I'd wait rather than interrupt you. But service animals were mentioned in one of your slides, and we also had a question about about assistance animals, service animals, and so I'm just gonna. That's certainly an entire presentation on its own, but I'll just note a few differentiations we can make that apply here. The first one, and probably the most important one, is differentiating between a service animal and an assistance animal, or what's often informally referred to as an ESA, or an emotional support animal. As a general matter, an emotional support animal or an assistance animal is only required in housing, which does not translate in 99% of cases, does not translate unless there's a residential component to applied learning or experiential education programming. So what we're really focused on then is service animals, which are animals that must be specifically trained to perform a task that helps an individual navigate or deal with the disability, helps alleviate a symptom, something like that. But it's got to be a trained animal. Certainly a guide dog is the sort of the classic easy example. The area that often sort of that we get into with in terms of clinical rotations or clinical experiences is where you have a hospital or a clinic or a school saying, less likely a school, more likely in the healthcare setting, saying, no, you can't have an animal on this floor. You can't have an animal in this facility. And just a blanket statement like that is not going to get you very far.
Mhm.
You really need to be able to argue that having the animal poses a direct threat. And in an OR, you can probably make that argument. In a general patient care wing of a hospital, that argument's not really going to work, especially if you have a trained animal in that environment. They're often going to be permitted. Really, labs and operating rooms are a couple of the examples of places where animals are actually not permitted. So those are often the request for those animals often leads to some touchy, difficult conversations with our colleagues, our partners, particularly in clinical areas, where we're explaining to them, no, you actually don't have a choice here. You're a place of a public accommodation. We're an education provider covered by various laws, and oftentimes those service animals are going to be necessary. The question also talks about, are you seeing more requests for assistance animals? I assume that's related to another sort of quirk of the law here, and that is that in the employment context, an animal that is not a service animal can be requested as a potential reasonable accommodation. But in that context, sort of separate from the housing residential life area, you really can engage in an interactive process and determine what is the best available accommodation for the individual. And that doesn't always have to be an animal. In fact, in my experience, most of the time we can offer an accommodation that alleviates the symptom or helps the individual with the disability that is not the animal. Sorry about that. My light went off. Always goes off in the middle of these presentations. Not moving around enough. The other question that came in that I just want to address here quickly is how unprofessional conduct can translate into the sort of disability context. The fact is that it's often raised by students when they are accused of or in the process of being held accountable for unprofessional conduct, that they will state that this is tied somehow to a disability. And usually it's a mental health disorder of some sort, a mental health issue that causes the student, or the student is saying, causes me to act out in a particular manner that has been interpreted by a supervisor or by, as we mentioned earlier, a room full of students as inappropriate. And so that's one of the areas that we'll look at. Rarely are either sites or schools, colleges, universities required to put up with behavioral failure to meet behavioral expectations, regardless of whether those are part of a related to a disability or not. Generally, those behavioral expectations are considered, for lack of a better term, a fundamental aspect of the program. It's fundamental that you comply with all the behavioral expectations, which often are sort of translated through the language of professional expectations.
Right, and these student arguments are losing at trial, okay, or before trial. Usually there's a summary judgment offered, but the college university still has to go through the process of defending its reasoning in not permitting this kind of, it's often depression or other sorts of psychiatric disorders that make it difficult for the student to interact in a professional manner. And it is a mental health issue, so it is disability. But that doesn't mean that you need to accommodate the disability by allowing that misconduct to occur. The courts are firmly behind you on that one.
Very good, thank you. So moving on here. Some things you want to put in agreements. Obviously, again, agreements and applied learning are a totally different topic and could justify an entire session, but a few things related to disability accommodations that I think are helpful to have in agreements. Certainly, and this is the easiest one, is a non-discrimination clause. I think in any kind of agreement that you want to have some kind of statement that the parties agree to not discriminate on the basis of many protected categories, and certainly including accommodations or including disability. To the extent that you can add language specifically addressing accommodations, that's great. you're not going to get it in a lot of cases. They're going to take it out because they're going to say we have our own process. And we're going to, we're going to assess that based upon our own accommodations process. We're not denying that we're going to offer accommodations, but we're not going to specifically agree sort of in the contract to do that because they don't want to bind themselves to some other process outside of whatever they have at the site. But if you can get it, it's helpful. Make sure having a coordinator a specific coordinator is identified. Relationships matter here. I can't emphasize that enough. When boots hit the ground on dealing with these issues, if you have a relationship that you can pick up the phone and call an individual that you worked with, that you've been working with, that you've talked about the agreement with, that you've maybe been through past issues with before and dealt with other students on, that's going to be extraordinarily helpful. I say have lunch once a semester. I think keeping in contact, because these issues tend to pop up, periodically. Everything can run. You can be sending many students to a site for years and never have an issue, and then all of a sudden you have a big one where you're going to be co-litigants. So keeping those relationships close, keeping on a very familiar basis with whoever you're going to be working with, I think can help head off a lot of problems down the road, create trust between the parties, make sure that you're both on the same side, and that's going to help you sort of support the student in many cases as effectively as possible. Again, another tough one to get, but if you can get it, having the site specifically agree that they will cooperate with your internal investigations is great. It's especially great from a Title IX perspective. It makes life a lot easier when you have a complaint come in, but it's also helpful in this respect. We all have policies that enable students with disabilities to file complaints internally on campus, and to the extent that if they are filing a complaint about a site or a placement that they've been sent to and something that's going on there, or an accommodation they're not receiving, or discrimination they're facing, to the extent that you can pick up the phone again, that you can actually go speak to or remotely speak to individuals at that site and in order to help inform your investigation of it, that's great. A lot of times, even if I will say, even if you get the language in the agreement, they're going to shut down and probably not want to talk to your investigator. They're going to want to do their own investigation. But I think, again, if you have those relationships and you have the language, then you can cooperate on these things in a way that, again, we all know if you can do an effective internal investigation and reach a result, it's going to set you up. It may not make the complainant happy in all cases. It may not head off the OCR complaint or the litigation or whatever it may be, but it will set you up for being able to defend that more effectively. And so if you could explain that to your partners and have the language to fall back on in the agreement, that's the by far the most effective way to deal with it. All right, we mentioned we'd be talking about technical and academic standards before, and it is a big part of this. It's really probably the preeminent way you set yourself up for success here. It's one of the few things that we control about the whole process, is setting this up, and we don't control them in that we can make up whatever we want, but we control them in that this is an area where we can focus our attention, we can focus our efforts and get it right and set ourselves up for as much success as possible. Barbara mentioned a few of the sort of benchmarks that you want to focus on earlier. You want to make sure that the technical academic standards are constructed by experts, that those experts have considered alternatives and determined that this is the appropriate standard to have in place because it meets some learning objective or licensure requirement or something like that, and that there's been a careful, rational review of the program requirements. And again, you're looking at things like professional obligations, licensure requirements, learning outcomes, and tying the technical and academic standards directly to those. They're also going to be tied in many cases to the practical requirements of the placement site, whether it's a hospital or a school or a business. They're often going to have particular requirements that tie to those. But from our perspective, we're often looking at the requirements, what's needed in order to perform from the academic standpoint. And I think Barbara will agree, that's where we have the most, that's where we're going to get the most deference from courts and from OCR and places like other administrative or regulatory agencies. So I say you want to be in the Goldilocks zone. What do I mean by that? You want to be firm enough that the technical academic standards have teeth, that they are real, that they are going to be that you can apply them, and that they have meaning. But you also want to make sure that they are legitimate, and then that you're not just throwing in a bunch of things that would be ideal but maybe not required. So you want to find that area in the middle where they are legitimate, they are solid, they are something that you can rely on, they're actionable, but they don't go too far and require things that may, be in a perfect world. Everybody would be able to meet the standard, but it's not actually required for success in the program. Routinely updating. I say this, I've sort of always been saying this, but over the last couple of years, it's become, I think, even more important to update, and especially if you haven't updated since the pandemic and technical academic standards related to any of these programs. Now is the time, because remote and hybrid paths through many of these programs have been implemented, and we are doing things differently now than we were a couple of years ago. And you want to make sure that technical and academic standards reflect how you are actually doing things, not how you did them 3-4 years ago when everything was in person. Maybe now it's not. We're going to talk about remote learning aspects of this in a little bit, but I will just offer one example here, and this is actually pre-pandemic, where I was involved in a case where an institution instituted a new online bachelor's in nursing program, and basically took the requirements from their existing RN program, and put them in place and said, these work for the bachelor BS program as well, because of course you need to be successful as an RN before you can go on and get your bachelor's. Well, somebody almost immediately came and made a complaint and said, why do you have requirements about needing to ambulate between courses? Or these it was an individual with who's in a wheelchair saying, I'm doing this whole program from my desk and my computer. Why are you telling me I need to be able to carry X amount of weight from one room to another? I'm literally sitting here. And on top of that, the individual said, and I've been practicing telehealth as a nurse, practicing nurse, for several years. So you have someone who is successfully already practicing as an RN and was rejected from a bachelor's program because of requiring academic standards, technical standards that clearly didn't apply to that program. You can imagine, so that was pre-pandemic, but you can imagine a lot of that kind of thing happening now, where you used to do things in a certain way, where maybe technical standards applied, and now you're doing them in a different way, where those same standards aren't going to apply. So really look at those, look at them often, review them. I think, as Barbara said, getting sort of a group of experts together that can all give input is certainly a best practice, but at least having somebody take a rational look at them regularly, if you can't get the whole group together, is highly advisable. So you want to work with the clinical sites, and if the standards are coming from the site, you want to question them, for lack of a better way. You want to make sure that you understand them, that you can reduce them to writing, that you agree with them, and that they're legitimate, that they aren't imposing requirements that go too far, that don't hit that Goldilocks zone. It's going to help us also understanding the requirements of a particular site is going to help us direct students to the right place, because we're going to learn through that process about how this particular rotation of this program works, how it actually plays out on location. So, and finally, it's okay to ask applicants if they can meet the technical standards of a program. If they don't, I think a best practice, and Barbara just pointed this out to me before in the last couple of days, a best practice is you sort of automatically, if a student says they cannot, treat that as though they are requesting an accommodation, and you consider, obviously in concert with the individual, whether there's an accommodation that would enable them to meet the technical standards of the program. I don't know if there's anything you want to add there, Barbara. Finally, and we mentioned this earlier, but I'm just going to hit on it one more time because I think it is important. To the extent that these standards reflect academic judgment, you're going to get more deference. And I didn't get to it yet, I'll be honest. I told her I might, but Barbara just wrote a whole new article in the Journal of College and University Law about academic deference for academic judgment. So get to that when you can. I know I will. And I'm sure will help illuminate some of these issues for even further. All right, pre-placement considerations. We kind of alluded to this earlier when we were talking about behavioral issues. And one of the things that you can do, particularly in education, health, mental health fields, you often have faculty, whether they be adjunct or full-time faculty in the classroom, who have real life experience in the field, who used to be practicing, who used to be teachers, and now they're educating teachers, who used to be practicing in health sciences, and now they're educating. Use those individuals to as an early warning system to cite potential problems. And what do I mean by that? If you have a student who is not complying with behavioral standards in the classroom, somebody may be able to bring that to your attention and say, we need to watch this. We need to sit down with the student and talk about how that would play out if you did it in a clinical or a educational setting, and really have some sort of heart-to-heart conversations with students about whether they're in the right programs. It could be something as simple as the student sits in front of the class and has a hard time reading what's on the board or the screen, and a faculty member may be able to say, I don't know how that student is going to be able to read an X-ray if they're sitting right here and they can't read the screen. Let's talk to that student about how this is going to work, because I'm seeing it now. Better to get to the student now, figure out how this is going to work, whether it's going to work, whether this is the appropriate program, rather than wait 2 years until they actually begin their clinical rotations and then have a problem occur. And direct students to the places you can work with. I mentioned this a bit earlier when we were talking about it. The more you know about the placements, the better you can do, the better service you can do to your students in terms of directing them to places where they are going to be the most successful. You want to make sure those technical standards are clear, and we want to encourage and direct students to the right sites where they'll be the most successful. At the same time, so there are sort of see it as two parts. Can they be successful, and where they're going to be the most successful? And we want to be considering both of those things. On the technical standard side, we're sort of setting a minimum, but we also want to be looking, sort of at the best possible placement, not just the one where they meet the minimum standards in all cases. All right. As we're working with partners, and I've talked about relationships before and how important it is, you want to make sure that that we understand if they are talking about if they have a technical standard, or if they are saying an accommodation is a fundamental alteration. We want to understand why they are saying it, work with them, push back a little bit in many cases, and have them explain to us what we are going to have to potentially explain to a court or to a regulator someday. And we do the advocacy part on behalf of the student in many cases, or we help the student with the advocacy. We make sure we're sort of testing each other. We're testing to make sure that their explanation for a fundamental alteration, or why something would be a fundamental alteration, holds up. It holds up under our analysis. If they can't do that, and this is one of the most difficult from my perspective, one of the most difficult times to counsel a client. Sometimes you just have sites that won't listen and they just say, I can't do it, or I was already, this was already a bit of a burden, but I was going to do it anyway. I was going to take these students. But now you're telling me I have to let a service animal in, and that's just too much for you. I'm not going to do it. There are times where if you are working with a partner who is no longer acting like a partner because they are not abiding by something which is fundamental to our goals and our missions and our legal requirements, where you're going to have to cut ties. Now, if you have those relationships again ahead of time, I think that's going to be much less likely, but it is not impossible, and you want to at least sort of be conscious of that is a potential factor. And what you don't want to do is send futures, sort of pull one student out and keep sending students there, because it's someplace we're only going to send the students who don't need the accommodation. That's usually not a good route to go. Usually you have a partner who is not reliable. So addressing student complaints, we've been sort of talking about this throughout already, I think, but you want to be thinking ahead of time about what procedure controls. Is it going to be your internal procedure first? Is there an employment relationship? So is this going to be at OCR? Is it going to be at EEOC? Is the complaint likely to come into the placement site, or is it likely to come into the school? If it comes into the school, how are you going to work with the placement site to respond to that? That's particularly touchy sometimes with OCR, I can say, because we are sort of translating what is happening at the placement site back to OCR and justifying it. And saying, here's why we think, here's why we run the program this way. Here's why we think the partner's doing it right, because they're basically running part of our program for us. And we're gonna have to explain it to them. Generally, you're not going to work with EEOC too much, because that means if EEOC is involved, they're probably investigating this as an employment infraction, which is we're going to kind of step back from and say that's between the student and the site. We're not really involved because we're clearly not the employer here. We may have some sort of peripheral involvement, but we're not going to be directly involved. So just thinking ahead of time about how you're going to, particularly if you're going to be working through OCR with a third party, with the placement site, how that's going to work out. And then again, balance sort of advocating with this for the student, with the site, with being prepared to defend your position. And oftentimes those are the same thing, because if you're advocating for the student, you're advocating for the legal rights of the student, you're doing your job as an institution, which is going to help you defend your position later on in the future. If it comes down to a balancing, it's 50-50, you don't know which side to take, we're educators. We take the side of our students, is sort of the approach that I think that most clients go with, most colleges and universities want to go with, even though it's difficult sometimes because you've got long running relationships with our partners. And then finally, remote hybrid considerations. I talked about it earlier a little bit, but they have the potential to open up really great new possibilities, new opportunities for students, particularly in economically disadvantaged students, or students who are in rural areas potentially, and can't pick up and travel to Palo Alto or New York or wherever, Washington commonly, and it's too expensive and they can't take a job, they can't get the opportunity. If it's offered in a remote setting, oftentimes now those opportunities are available, but they're only available in as much as to all those students, in as much as they are also accessible. But we've done a lot, covered a lot of ground, made a lot of progress, making our programming, our educational programming more accessible over the last few years. But if there is a required practical portion of a program and that is not accessible, it doesn't matter how good our PDFs were, or how good our PowerPoint presentations were, or how good our captions were on our videos on campus. If when you send the student off campus, they don't receive the accommodations they need, or they don't have the accessible access that they need in order to be successful in the program. So make sure that you're sort of, I guess the takeaway from that is, make sure you're looking at those things first. You're asking your partners, what platform are you using? Is it accessible? is it accessible under what standard? Is it WCAG 2.2A accessible? Sorry if I'm bungling that, but and then who's responsible ultimately if it is not immediately accessible for making it so, if it can be, for providing assistant aids or other technological support in order to make that technology accessible to the student. And I know I'm right up against the end of the time here. Sorry if we didn't get to a few of the questions. It's my fault for going too long, but we will look, I think we'll be able to look at these and respond directly to some of you.
Well, actually, Seth, there's the 3 that came in when you started your piece, are pretty much all about the same, reacting to a statement that they're not sure that you said this, but can employees request emotional support animals? This is not students, this is employees. And we had 3 questions pretty much about that.
Okay, so again, I probably went too far down the animal road there for such a, for a presentation that's really about larger issues. But as a general matter, an employee can make that request, but it doesn't have to be automatically granted. In the residential under the Fair Housing Act, oftentimes it's not automatic, but it generally has to be granted. You generally have to make an exception to a no pets policy to allow an assistance animal, even if it's untrained, to perform a specific task as a service animal would be. In the employment context, we have to evaluate it as a potential reasonable accommodation for an individual's disability. It's often not going to be. It is often not going to be the most reasonable or the one that you arrive at after engaging in an interactive process with the employee. Again, we're talking about students here, not employees. So that's really sort of beyond the scope of this particular presentation, but I am happy to talk about it with anybody anytime. I do like talking about these issues, and they do get interesting very quickly, but that is sort of another twist on the animal aspect of this. And yes, I just see at the bottom here, the request would go through HR. Yes. And then would refer back to whatever whoever makes those determinations on behalf of Human Resources. And I see that we are a few minutes over, so I don't want to go on too much further. So thank you all. Appreciate it. I hope to see you again in October for the 3rd in our series here. And I really, really, really want to thank Barbara. It was an honor really to present with Barbara, and a pleasure as well. And I hope you all enjoyed it. Thank you.